So I'd like to welcome everybody to one of ESUB's continuing education seminars. Periodically, every couple of months, we present these as basically a learning experience to the contractors that we come in contact with. Of course, our background prior to creating ESUB's project management, cloud-based software, is that we were consultants in the industry for 25 years. So we are very committed to education, to promoting our affiliate partners with regard to educational programs, and then supporting them ongoing. My name is Wendy Rogers, and I'm president of ESUB, and I'd like to welcome everybody here today for this very, very informative webinar that we're about to be able to participate in with Wally Zimolong. Let me give you a little bit of a background on Wally. He's one of Super Lawyer Magazine's rising stars of construction litigation, and he's dedicated his entire legal career to representing individuals and companies in the construction industry. Wally has successfully litigated hundreds of construction-related cases and has counseled clients nationwide on developing and constructing highways, multifamily apartment buildings, professional and collegiate sports stadiums, schools, and uniform planned communities. Wally has a particular emphasis on representing transportation contractors subject to federal and state disadvantaged business enterprise regulations and other regulatory regimes. He's a frequent author and speaker on the impact of these programs on construction firms, and he has a nationwide DBE practice. We're very excited to have Wally come and present this webinar that has received raving reviews. He's basically going to go over for us the advantages and disadvantages, of course, of the Disadvantaged Business Enterprise Program, specifically with regard to the aspect of compliance or non-compliance and the problems that, unfortunately, some contractors are unwittingly getting themselves into. So at this point, Wally, I'd like to go ahead and turn it over to you, and thank you so much for participating today.
Thanks so much for having me and allowing me to present on this very important topic to the construction industry, and one that I am regularly counseling clients on, it seems like on a more frequent basis each and every week. It's something that we saw very little of about a decade ago, and now, as one of my clients told me, who is a very large contractor and does work in Manhattan, contractors are scared to death of what's going on with this program, and every time I speak to a contractor in the transportation sector, this is the first and number one thing that comes to their mind when I say, what's keeping you guys up at night? I'm trying to, did you turn the screen over to me so I can flip through these slides?
Sorry, hang on just a second, Wally. Nope, to the right. Hang on just 1 second.
Sorry, folks that are listening out there. We're just trying to get a little technical bug here so I can control these slides.
Technical difficulties. Hang on, everyone.
The webinar is run by GoToMeeting and not ESUB. I'm going to underscore that. They did not write this code.
Yeah, right. Okay, Wally, you should hopefully, we've gotten this fixed on our side.
Okay. Well,
is it working?
I believe so. I'm just trying to see if everybody's seeing the next slide, the background on the DOT's program. Yes, no.
We're seeing actually it looks like your desktop.
Oh, okay. Oh. Well, I'm trying to see here. I can get these slides. Hold on for a second. I thought that was, bear with me. How's this working for everybody?
So yeah, it looks like at this point we're seeing
Okay.
background on DOTs. There is some extra stuff though.
Okay.
Just if you enter it in, I think for full screen.
How's that?
There we go. Bingo.
Okay. We're back. Sorry, folks. So getting back to the topic, a little background on the DOT's DBE program. The regulations were first became effective in 1980 in the Highway Transportation and Funding Bill passed that year. Congress has reauthorized the program every year since 1980, including the most recent Highway Funding Bill, the MAP 21. There are similar, if not identical, programs at the state, county, and municipal level, all of which are very important to follow. What we're going to be talking about today are primarily the regulations that are promulgated under the Department of Transportation's program and the Federal Highway Administration. But as you'll see, the state, county, and municipal DBE programs are equally as important. One point of emphasis, I'm going to refer to the DBE program, the Disadvantaged Business Enterprise. That includes minority business enterprises, women business enterprises, and then other disadvantaged individuals. So when I reference DBE, I'm referring to all three of those. These programs, as you can imagine with any sort of set-aside, they're controversial, but they are constitutional. Now, why is it that my clients are telling me they're scared to death of these things, of this program? It's because, number one, folks are facing jail time and civil fines and penalties for failing to comply with the programs, and we're going to get into some examples of those. Number two, and I really think this is perhaps one of the largest issues out there regarding non-compliance with DBE programs, whistleblower, False Claims Act lawsuits, and we'll talk a little bit about those, about how private individuals are given incentives by the government to bring claims on behalf of the government for fraudulent claims, and how the plaintiff's bar is aggressively recruiting whistleblowers to bring actions against contractors that violate the Disadvantaged Business Enterprise Program. The third area is you could see a rejection or challenge to your bid. The Transportation Authority may reject your bid after spending significant dollars in preparing that bid. You can also see a competitor bring a bid protest to seek to have what is otherwise an awardable contract thrown away. And finally, transportation agencies and other authorities maintain the right to perform a post-completion audit of your project, and I'm sure no one wants any government regulator sniffing around and performing such an audit. So an overview of the requirements. 49 CFR 26 is where you're going to find the DBE regulations that relate to Federal Highway Administration projects, Federal Transit Administration projects, and also airport projects from the construction side. There's a similar set of regulations that appear at 49 CFR 23 that relate to FAA airport concessions that are actually inside the airport. They actually have a DBE program for folks that are actually working at the airport as well, but we're not going to be discussing those today because they don't necessarily affect contractors. The major components, the DBE set aside, the percentage of work that the transportation agency designates as being required to be subcontracted to disadvantaged firms is merely a goal and not a quota, and we're going to see how that gets folks in trouble. You must use good faith efforts to meet that goal. If you use good faith efforts and you don't meet the goal, that's fine. And commercially useful function, remember that term. Your DBE must perform a commercially useful function, and we'll talk about what exactly that means. So who is it on a project that needs to comply with these regulations? Obviously, prime contractors, which are defined as those having that direct contractual relationship with the Federal Department of Transportation, a state transportation agency, or a county and regional transportation agency receiving federal funding for a project. A regional transportation agency would be any of these alphabet soup type of agencies that operate mass transit in a metropolitan area. I'm in Philadelphia, and we have what's called SEPTA. That's the Southeastern Transportation Agency. You have the PATH in New York, the Port Authority Transportation, and various other agencies. Subcontractors and sub-subcontractors also need to pay attention to the DBE rules and regulations because, number one, if you look closely at your subcontract, for those that are in privity with the prime contractor, it will surely have some sort of language that you are to be in compliance with generally all laws and perhaps more specifically the DOT's disadvantaged business enterprise rules. And if you're a sub or subcontractor or subcontractor that happens to be a DBE, of course you're going to want to abide by the DBE rules as well. Again, stepping back a little bit, what are the major requirements? Good faith efforts. If you're a contractor that is bidding on a project that has a DBE goal, you must demonstrate to that transportation authority or agency that you have utilized good faith efforts to meet and maintain the stated DBE goal. Now, what are good faith efforts? And we'll talk about that somewhat. They're real, sincere efforts. And there's ways that these efforts should and must be documented. And the nice thing about eSub and some of the platforms that they offer, it's a great way to use technology to document your good faith efforts so that when a regulator comes knocking, you can easily turn over a package of documents or electronic data that demonstrates that you are in fact in compliance with your good faith effort requirements. For prime contractors, it also doesn't end simply at the time of demonstrating your good faith efforts to meet the goal. You need to monitor compliance as well. And again, count only those DBE firms that are performing a commercially useful function and to make sure that DBEs are in fact performing a commercially useful function. A little later in the slides, we're going to go over some red flags as to what qualifies as a commercially, or what you should look for when you think someone may not be performing a commercially useful function. I mean, good faith efforts and what you need to do to maintain it, I could spend an hour on that, but generally speaking, it needs to be real and sincere. The regulations have a definition of commercially useful function, which is set forth on the slide. If I could sum it up in layman's terms, what it means they're actually performing work. They're performing work as a real contractor, and then the regulations sort of work back from there in legal terms as to how do we define what it means to be a real contractor. They're actually managing the work. They have real employees. It's their trucks that are showing up at the site. It's their management that's showing up at the site. It's their regular employees that are showing up at the site. They're not borrowing equipment. They're not slapping stickers on the sides of someone else's trucks. They're not shuttling employees between payrolls. Things of that nature are things that you need to look for when it comes to whether or not a DBE is performing a commercially useful function. Importantly, there is one bright line of all the sort of general guidance that the regulations provide. There is one bright line test that the regulations provide, and they say, at a minimum, a DBE must perform at least 30% of the subcontracted work with its regular employees. It's okay for a DBE subcontractor to subcontract to a non-DBE as long as that portion of the work is discounted from the overall goal and what is reported to the transportation agency. But as long as it remains above 30%, you're going to remain in compliance. So I alluded to in the beginning of the program that for probably about the first decade or so of my career, even though I represented numerous contractors and worked with contractors that dealt with the program and actually worked with some DBEs themselves, we saw very little in the form of compliance enforcement actions. And that started to change. You just started to hear things anecdotally around 2010, 2011, and that's no surprise because when you look at the pace of investigations brought either by the Department of Transportation Inspector General or the Department of Justice, you can see that what we were hearing in the field was more than anecdotal. And I'm going to give you some statistics to drive home the point about why the regulators and the authorities are watching you. These are stats taken right from the DOT. DBE fraud represents over 1/3 of the current DOT Inspector General open cases. From 2009 to 2010, the number of open DBE fraud investigations increased by almost 70%. And from October 1st, 2003 through September 30th, 2008, and by the way, this through September 30th, 2008 was the most recent data we could get. There were 49 indictments, 43 convictions, $42 million recovered, and 419 months of jail sentences handed out. This number has certainly increased. I've monitored it. In fact, just last week, there was the final sentencing in one of the cases we'll talk about, the Schuylkill Products case, where one of the executives, I think the ultimate sentencing was somewhere along the lines of 10 years in prison for failing to comply with the DBE regulations and engaging in DBE fraud. So when I refer to DBE fraud, what am I referring to? Well, there's two of the most common and probably the only type of DBE fraud. One is what's called a pass-through scheme. It's where a certified DBE performs no commercially useful function. In other words, they perform no real work. Instead, they hire either the person that they have a contract with, employees on their payroll, or a non-DBE firm to make it look like the DBE was performing the work. They receive some sort of commission or percentage simply for the prime contractor to use their DBE status to meet their DBE goal and to submit their payment applications. The second type of DBE fraud is what's called a front scheme. Here, the DBE actually performs the work. However, it's not actually owned and controlled by a socially and economically disadvantaged individual. I could spend an entire webinar talking about what are the requirements to get certified as a DBE. It's something I do quite frequently. Generally speaking, one of the requirements are that the DBE must be owned 51% or more and be controlled substantially by what is referred to as a socially and economically disadvantaged individual that could per se be a female, excuse me, or a minority, and it technically could be a white male if he was able to prove that he was socially and economically disadvantaged in some way, but the test is a little different in that situation. So the two biggest DBE compliance misconceptions: number one, I'm okay because I use certified DBEs, and what I don't know can't hurt me. The first thing that's false about these two misconceptions is that in probably 99% of all DBE fraud cases, they involve the certified DBE, someone that had gone to the certification agency and received a DBE certification, had gone through the process, had been investigated by the certification agency and passed all the tests. So just because you're using a certified DBE does not mean you can just file it away. What I don't know can't hurt me. Totally untrue. You'll see how that really can hurt you in the area of whistleblower litigation. You have to pay attention to this stuff, and if you have any sort of inkling that there may be some DBE fraud going on, either a pass-through scheme or a front scheme, you need to pay attention to it. So I talked about the pass-through scheme. That's where the certified DBE does not perform any actual work, and a non-DBE performs the work, and the DBE just gets a kickback for being able to use their DBE status. And this is not something that's just for small contractors out there. The biggest names out there are getting caught up in this. Tudor Perini being one of the contractors that was involved with a DBE fraud investigation and prosecution by the Department of Justice. U.S. versus Maristilian involved the former president of what was then Perini's civil division, and on numerous projects in the New York metropolitan area. Perini was claiming that a DBE subcontractors or certain DBE subcontractors were performing work for Perini. Perini was then using those DBEs towards their accounting goals that they committed to with the various agencies that they had contracts with, excuse me. But in reality, as is the case in a pass-through scheme, the non-DBE contractors were performing the work, and the DBE firms were simply getting a 3 to 5% commission on the value of the subcontracted work. The president of Perini was indicted by the Department of Justice. He was found guilty, and tragically, he committed suicide before sentencing. One of the co-defendants, who was the head of purchasing, paid $100,000 in fines. We can be sure that the legal fees were 3 times for that, and he was placed on 1-year probation. For Perini's role, they had to pay nearly $10 million to the DOT to settle the matter. What's important about a case like this is that it's not only the contractors that get popped for this, it's the individual officers and directors of the company. So it's not just a civil thing where Perini paid a fine and they could afford it, no big deal. The president of their company was found guilty, and the head of their purchasing division was found guilty as well. And you'll see that theme repeated throughout some of the cases we'll talk about. Another example, U.S. versus Tullio, a case from my neck of the woods involving SEPTA, one of the agencies I referenced before, the Regional Transportation Authority here in southeastern Pennsylvania. They hired a, they listed a, the prime contractor in this case listed someone known as Pullinge Trucking, who was the certified DBE and subcontractor to Tullio on their DBE goals. Why that's important is, if you're a prime contractor that has a DBE goal, you can count subcontractors towards that goal. So in this case, JMG, who's a respected general contractor here in southeastern Pennsylvania, subcontracted with Tullio. Tullio subcontracted with Pullins, and JMG was able to use the amount that Tullio subcontracted towards its goal. In reality, Pullins performed no work. It was JMG who was lending employees and passing equipment and material to Pullins to perform that work, and in exchange, Tullio and JMG paid Pullins a fee, a commission, 2.5%. In this case, what happened was JMG, the general contractor, ended up paying $1.27 million in restitution to the DOT. Perhaps more significantly, they received a 5-year debarment, preventing them from bidding on transportation-related projects for 5 years, which if they were profitable projects, probably had a bigger financial impact than the restitution. Tullio, who was the subcontractor, the president of the subcontractor, Michael Tullio, was sentenced to 15 months in federal prison and ordered to pay $40,000 in fines. Again, it's not just the company that needs to worry about this, it's the executives as well. Moving on to the second type of DBE fraud, this front scheme. I talked about how the disadvantaged individual must have a real, substantial, and continuing ownership in the firm. They must own 51% or more of the shares, or if it's a partnership, 51% or more of the partnership interest. But it's just simply not ownership. They must have real control over the business, and the regulations go at some length as to trying to define what that means in controlling the business. An example of a front scheme, Schuylkill Products, one of the cases that I referenced before. Unfortunately, another DBE fraud case that occurred here in the Commonwealth of Pennsylvania. It's the largest ever DBE fraud case prosecuted. The fraud occurred over the course of 15 years on 300 projects to the tune of $136 million in fraud. And it involved a firm, Markina Construction, who was a certified DBE. Markina was obtaining contracts from the Pennsylvania Department of Transportation, and it was utilizing its DBE status to obtain those contracts. So it was the person bidding on the projects, or excuse me, the firm bidding on the contracts, and it was using its DBE status to obtain those contracts. However, they performed no work, and which means it was not only a pass-through scheme, but as we'll talk about, Markina was not actually owned and controlled by a socially and economically disadvantaged person. In fact, it was controlled by a white male. Each defendant, when I mean each defendant, I mean each individual that participated in this DBE fraud received between 24 and 33 months in federal prison. The final defendant, who was just sentenced, and it happened after I made this slide, was sentenced to approximately 10 years in prison, $119 million in restitution, on top of several hundreds and thousands of dollars in fines, and plus they had to pay their legal fees, which probably pushed close to that. So when I talk about DBE fraud and I talk about prosecution for DBE fraud, what's interesting is there is no crime per se of DBE fraud. What you are guilty of when you commit a DBE fraud or do not comply with the DBE program is mail or wire fraud, conspiracy, money laundering, racketeering, or making false statements. I just want to focus on the first two, mail and wire fraud. Mail and wire fraud, if you talk to federal prosecutors, are their best friends. Generally, mail and wire fraud, you've committed mail or wire fraud when you use either the mail or the telephone or internet, the wires, to further a fraud. Now, how that happens on a construction project is every time you submit a payment application saying that, hey, I'm using 25% of my subcontracted work is performed by DBEs, when in fact it's really only 15%, you've committed mail or wire fraud. That's how that happens. Now, you recall that I started off at the beginning of the presentation saying that I think that whistleblower false claims lawsuits may be a bigger issue than actual prosecution by authorities for DBE fraud. And the reason is there is only so many, there's only so much prosecutorial resources to go around, meaning they can't prosecute everybody. They're going to pick the biggest guys, the most high-profile cases, and hopefully it scares the rest of us straight. It's just like with drug dealers. They don't bust every drug dealer, but when they do get the big fishes, they make a big deal about it, and hopefully that scares enough people away. Whistleblower lawsuits. There's something called the Federal False Claims Act. And for you history buffs out there, this False Claims Act dates back to the Civil War. It was originally referred to as the Lincoln Laws, and it allowed private individuals to bring action on behalf of the Union to folks that were gouging the Union for war goods. But it's remained on the books, and as you can imagine, it's changed in various different ways over the years. But the premise remains the same. Currently, the Federal False Claims Act authorizes a private individual to bring a civil claim in the name of the United States against anyone who fraudulently obtains money or property from the government. It gives these private individuals an incentive to receive up to 30% of what is recovered on behalf of the government as a bounty. And as I like to say, it makes former or disgruntled employees bounty hunters because now they have an incentive to bring a claim against you. I also mentioned it's a growing area of interest for the plaintiff's bar, the trial lawyers. If you go online and do a Google search, you'll see there's dedicated websites actively recruiting employees of construction companies that may have knowledge of fraudulent activity on behalf involved with a transportation-related project or other federally funded construction project. What are the elements of a False Claims Act? Well, you need to make a claim. It's got to be false. It's got to be knowing conduct. It's got to be material, and you have to have the intent of the government to pay. What is a claim? A claim is a request for payment. If you're working on a transportation project and you submit a payment application, there's going to be some sort of form that each transportation agency has, which you're going to be required to list your DBE participation, how much of your payment request relates to requests for payments by DBE subcontractors. And if that's false, you've now made a claim for payment. Now, knowing conduct. I need to underscore knowing conduct. It's simply not intentional conduct. The Act defines, the False Claims Act defines knowing conduct as actual knowledge, willful ignorance, or recklessness of the fraud. So that means if you're a prime contractor and you're submitting an application for payment to the government each month, and you suspect that some of the folks that are either subcontractors or subcontractors are maybe not who they say they are, there may be a front thing going on, there may be a pass-through scheme going on, and you don't investigate it and you don't do anything about it, and you just turn a blind eye to it, you've committed a False Claims Act violation because you've demonstrated deliberate ignorance or recklessness of the facts. An example here in the slides of a whistleblower claim and how it came about. U.S. versus Testec. Testec was a certified DBE. Remember what I said. Almost all DBE fraud actions involved certified DBEs. There was no allegation that Testec did not perform a commercially useful function. It was rather that a claim that Testec was not actually owned or controlled by a socially and economically disadvantaged individual. The claim was that Test Tech was actually controlled by a non-DBE firm. Again, I think it was a firm owned by a white male. The claim began as a whistleblower lawsuit, and why these things are so attractive is that when a whistleblower lawsuit is filed, it's filed under seal. A copy is sent to the Department of Justice. The Department of Justice has the option of taking up that case, the prosecution of the case, from the private plaintiff. But the kicker is, if the Department of Justice, on the taxpayers' money, is successful in recovering money for the government, that private individual that first filed the case and maybe did nothing but file the case is still entitled to up to 30% of the proceeds. And you can see why that's so attractive to attorneys. In the Test Tech case, the individuals involved were ordered to pay $2.8 million in fines. And for his part, the individual that, the former employee that brought that action, that initiated it and brought it to the attention of the Department of Justice, he received $562,000. There's a matter that's on my blog, which was also that came into the attention after these slides were created. It was involving a Chicago firm. The whistleblower wasn't even a former employee. He was a project manager of one of a non-involved subcontractor. He brought the whistleblower complaint. Department of Justice picked it up, and he made $2 million. So instead of just having the limited resources of the Department of Justice looking over your shoulder, you now have every eyeball on that construction site looking at you to make sure you're in compliance with DBE regulations. And not only that, there's a tremendous incentive for them to find fraud and bring it to the attention of the DOJ because of the dollar amounts that they're likely to be entitled to. You know, somewhere between, on the low end, this gentleman received $500,000 and the other gentleman received $2 million, and they're just two cases. Remember, lack of knowledge is no defense. It's not a defense either to a criminal indictment or a whistleblower action. There's actually something called the ostrich instruction in a criminal trial. It's a jury instruction given that if the defendant claims lack of guilty knowledge, but the evidence supports an inference that they deliberately avoided it, then you should impute actual knowledge. Just a quote from a case that talked about this ostrich defense: the failure to ask questions that would certainly arise from the circumstances is evidence that could lead a jury to determine the defendant deliberately avoided learning about the scam. Again, if you're on that project, you're the prime contractor or a subcontractor that has a DBE, and you think there is an issue and you do not ask questions and you claim, hey, I didn't know about it and I didn't want to know about it, that's not going to save you. I gave you that definition earlier of what knowing means in the context of the False Claims Act. It's actual knowledge, deliberate ignorance, or reckless disregard. Proof of specific intent to defraud the government is not required. So we talked about some red flags to look for. DBE owner provides little or no supervisory work. You don't see the person. You never talk to the person. You don't know what they're doing. The superintendent, the foreman of the DBE is not somebody that is their regular employee, maybe shuttled from somebody else's payroll. The equipment used is being leased by a non-DBE. You see magnetic signs over a non-DBE's logo. A prime contractor is paying for a DBE's materials. There's a series, while joint checks are not invalid per se, there's a series of joint check agreements. And you can review these at your leisure. I can provide anybody that is interested a copy of these slides. Bid rejections and challenges. This is really where I think ESUB can help you folks. Is that if you remember what I said, quotas are not permitted. The DBE program is not a quota program. It's not a quota program because the Supreme Court says you can't have quotas. And in fact, if you look at the DOT regulations, they say flat out, these are goals and not quotas. Importantly, your bid cannot be rejected for failing to meet a DBE goal. However, if you fail to meet the DBE goal, you must demonstrate good faith efforts in attempting to meet the DBE goal. Demonstrating good faith efforts. There's actually an appendix to the regulations that demonstrate it. You, through all reasonable means, aggressively solicit DBEs to perform available work. You try to break out your contract to increase the likelihood that DBE goals will be achieved. Subcontracting work that you intended to self-perform, and negotiating prices with DBEs. So when you're going out to bid and you're trying to recruit DBEs to bid on your project, you have to be sure that you aggressively recruit them and that you maintain accurate records of them. This is one way the eSub software can help you, is that you just can't send out a blast email to all the DBEs that you have a list of saying, hey, please bid on our project. You need to be able to demonstrate these are the attempts to contact the DBEs we made. These are the steps we took. We sent an email. We took an ad out in the trade publication. We sent a subsequent email. We made directed phone calls. If you could list all of those and you could turn it over to the DOT if they're challenging your bid as not being in compliance, you're going to win. Even though you didn't meet the good faith, even though you didn't meet the goal, you can show you took aggressive efforts, and you can list them, and you can be specific, and you can back them up with specific instances of what you did, and you can train your procurement departments properly. You're going to win that. You're going to win that bid, regardless of whether or not you met that goal. But you got to be able to show it. And we work with firms on a regular basis on coming up with programs to make sure they can document and demonstrate meeting those goals. There's also a post-completion audit, another reason to keep accurate records of your good faith efforts. If you're not making, if you don't have those records, and a post-completion audit is performed, you can be disbarred, you can be subject to perhaps restitution, being forced to pay back monies. It really depends on what remedies are available to the local transportation agency, but it's not something that anybody really wants to be involved with. One example of a post-completion audit clause, it's my understanding that these clauses are universal. I took the one from PennDOT, but most transportation agencies have them. If you look closely at your contract, it's that at the completion of the project, PennDOT will review the actual DBE expenditures to determine compliance with the DBE goal. If the DBE goal is not met, a written explanation from the contractor will be reviewed by PennDOT. If the shortfall in meeting the DBE goal is determined to be unjustified and unwarranted, PennDOT may impose sanctions where appropriate. Again, you can see that this is where it becomes important to document how you're interacting with your DBEs. One other thing before I move on to this slide. So the DOT reserves the right to summarily reject your bid if you do not meet or exceed the DBE goal and you can't show good faith efforts. The other thing that you need to be wary of is the second low bidder on a contract. The reason is that generally speaking, procurement occurs as follows. And this is throughout the country. Bids are awarded to the lowest responsible and responsive bidder. And how you can have your bid challenged by a second low bidder is you may be low bidder, and you may be responsible, meaning that you can actually perform the work, but you may have not been responsive to the bid because you did not state in your bid accurately the amount of work that the DBEs were going to be performing, or your bid does not meet the DBE goal. Now, you can be challenged on that, saying the goal was 10%, you were non-responsive because you put 5%. But if you have that backup data that shows what you did and your good faith efforts, you're going to be able to win that, and you can provide that to the agency that's subject to the legal challenge, and they're going to stand by you, and you're going to be assured that bid stands, and all your hard work and potential profit remains. Here's a type of letter that you can that you would get after a post-completion audit is performed. And I always say, would your firm survive this? Maybe some of the bigger prime contractors, but some of the smaller subcontracting transportation firms I deal with probably wouldn't. It's asking for essentially restitution in the amount of $1.8 million. So what do you need to do to avoid the long arm of the law or the greedy eyes of whistleblowers? First, you got to ask, what are you doing now for compliance? And when's the last time you tested your compliance program? What we do and we recommend, and something we do regularly for folks, is performing a DBE compliance audit. We actually take a project and look at it as if we were a DOT Inspector General agent or an agent with the FBI. What are they looking for when they're investigating the project? And are there any red flags that we see that we're finding before the regulators find that you need to be made aware of? The other things that we always ask, does your firm have a DBE compliance officer? Do your contracts contain DBE specific language? Do you record your good faith efforts? And are you inquiring about potential commercially useful functions, the red flags we talked about? The next step, once we identify through the audit process some of the holes in your compliance program, is to put in specific policies and procedures that we follow up with periodic testing to make sure that those procedures are being followed. This also matters in that we have seen, there's no written guidelines on this, and we haven't spoken to any of the prosecutors about this, but we've seen it in some of the case law that's come out and some of the news releases that have come out concerning DBE fraud, is that it appears that if you have a strong compliance program, prosecutors are willing to take that into consideration. In the financial world, there's actually a regulation and guidelines for prosecutors that if there's a compliance program and it's a robust one and it's real, that will matter when they're investigating a financial firm. The construction world doesn't have a corresponding regulation for prosecutors, but there's no reason that a prosecutor couldn't be persuaded by that same logic. I believe it was a case up in Connecticut where they were fined. The firm that was investigated was fined, but no charges were filed. It was settled prior to criminal charges, and perhaps most importantly, none of the executives were charged with a crime, and they avoided jail time. And the reason was, according to the press release from the Department of Justice, was that they had a DBE compliance program. They demonstrated that to the Department of Justice that they took DBE compliance seriously. And they had to pay a fine, and I'm sure it hurt their pocketbook, but it beats avoiding jail. There are a whole host of other federal regulations that we deal with that DBE compliance can help you with. Specifically, we've seen an agency underneath the Department of Labor known as the Office of Federal Contract Compliance Programs. I've had dealings with them more in the last 3 years than I've had in the last 3 months that I've had in the last 12 years. And there are DBE related issues when you're dealing with the Office of Federal Contract Compliance. That agency, who has become a very robust and aggressive agency, can audit and investigate any contractor regardless of size. There's no employee threshold. So long as they perform in the aggregate $10,000 or more of work on any federally funded project. That could be anything. And I'm hard-pressed to imagine a contractor that doesn't fall within the crosshairs of the OFCCP. But that's beyond really, the OFCCP could take up another webinar entirely as well, but I wanted to alert you to that, is that even if you're not working on transportation projects, if you're working on federally funded projects, the feds are still looking at this, and because of the mail and wire fraud, how broad it is, if you're using the mail, you're using the wires to commit a fraud, it doesn't matter if the feds are on the other end. You've committed mail or wire fraud, and you're subject to federal indictment. If you want to know more about what we do, I invite you to visit my website, zimolonglaw.com. There's a whole host of resources related to DBE cases on my blog, which is supplementalconditions.com. And of course, I'm sure the wonderful folks at eSub would be happy to talk about how what I think is a terrific software suite for the ease of use and whatnot could be utilized and tailored to meet some of these DBE compliance goals. And that's all I have. I can stick on. I don't know if we had planned for questions or whatnot, but I'm happy to stick around if anybody wants to utilize the question box. I'm happy to answer questions people have.
Wally, that was a wonderful presentation. Thanks so much. We do have one question. I'm going to go ahead and read it off for you. A gentleman wanting to know, he says, trucking seems to be a moving target. Are there specific rules that are acceptable to all contracting agencies, and where can we find that documentation?
There actually are rules that are specific to trucking agencies or trucking firms. They're in the 49 CFR 26. If this individual wants to get in touch with me, I can walk them through the trucking rules, but they're universal. They're not specific to any one jurisdiction. They are federal DOT regulations that apply to any transportation project receiving federal funding in the country.
Okay, great. If anybody else has questions in, we can go ahead and take them now. If not, Wally, I just want to thank you for a very informative, a little bit scary,
yeah.
keeping it real type of presentation. I appreciate it very much. As always, we are here at eSub to come in and provide these educational webinars. We want to thank everybody for attending today. Again, to find out more about Wally, check out his website. To find out more about eSub, cloud-based project management, document management, time card management for the specialty contractor market, please feel free to reach out to us. We will also be sending out an email after this webinar just thanking everybody for attending and giving you some more information on how to access a recording of this particular webinar. And I hope everybody enjoys their day. Once again, Wally, thank you so much. We appreciate it.
Thanks so much for having me, guys.
Sure.